case briefs, and so much more. LSData's got what you're looking for.
In 1984, the United States Court of Appeals for the Second Circuit heard the case Genovese Drug Stores, Inc. v. Connecticut Packing Company. The case focused on whether the recordation of certain documents provided legal notice to parties wishing to use a property for a specific purpose, even if they were not directly aware of the restrictions in place. The situation arose when Fotomat Corporation leased a parking lot from Connecticut Packing Company to operate a film processing business. Unaware that there was a restrictive covenant in Genovese's lease prohibiting the leasing of any part of the shopping center to a drive-in photo kiosk. As a result, Fotomat was prevented from operating due to a preliminary injunction. The main issue in the case was whether Fotomat had constructive notice of the restrictive covenant. Upon reviewing the case, the court determined that Fotomat had neither actual nor constructive notice of the restrictive covenant at the time of leasing the parking lot. Consequently, the court vacated the preliminary injunction and directed judgment in favor of Fotomat. Fotomat's claims against it were dismissed, and the case was remanded to the lower court for further proceedings. However, Genovese's damage claims against Bercrose and Copaco remained pending. Despite Fotomat being allowed to operate, the legal process continued to determine whether Genovese could secure damages from Bercrose and Copaco for breaching the covenant in the Bercrose-Genovese lease and Copaco's consent. Fotomat was also granted the right to recover the costs associated with their appeal.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.